Okay, CC students, I hope everybody's staying healthy and doing well, and to our campus, hello, and all the other campuses out there that are watching these videos and commenting. Thank you for your feedback. Hopefully they're helpful, and hopefully you're all staying healthy. This is the second of our Rules of Evidence videos. This is Rules of Evidence Part 2, Objections. And we've had a lot of requests for this, so we're putting this together for you. I want to talk about objections. And what are objections? Well, everybody who's familiar with trials that you've watched on TV, you see the attorney stand up and they say, "I object, Your Honor," and they give a reason for the objection. That's what an objection is. But why do we do objections? Well, they are, there's really two purposes, and they are to stop a question from occurring or to prevent an answer from occurring. And we'll talk more about that later. But the reason that we have objections are, overall, is that only admissible evidence may be offered and considered during a trial. So we don't allow all evidence to come in. And sometimes there's evidence that is admissible on its face. It may be relevant, and we'll get into that, but we exclude it because it would be too confusing for the jury. I've had homicide cases where photographs had to be presented in black and white, not in color, because to see blood on somebody would be too prejudicial for the defendant, and I've had to use black and white photos versus color photos. So that's a reason. Although the photos would be relevant, maybe they would the jury would have trouble with that. It'd be too prejudicial to the defendant. That's all I'm going to say about that. But let's talk about some objections that come from our CC packet. And what are the objections from the CC packet? I've laid them out here, and we'll go over these in detail. Next thing is, when do you do the objections? Well, the rules clearly say in our CC packet you cannot object during the opening statement and the closing argument, so we don't object then. We'll get into in the next video on how to do objections and the proper way to make them, but they occur typically when the question's asked. And there are times that they occur during the answer, but when you hear the other side make a question that's improper, that could lead to improper evidence being admitted in the trial, that's when you enter the objection. You stand up and you say, "I object, Your Honor," and you state the reason why, following the format in your CC packet. Who does the objections? Well, the attorneys do the objections. So if an improper question is being asked by the prosecution, one of the attorneys for the defense should stand up and make the objection. We'll talk more about it in another video. So that's what they are, when they're made, and who makes those, okay? We have in your CC packet an overview of, I would say, the 9 basic, now there are more, but the 9 basic objections that are raised during a mock trial in CC. The first is relevance. And what do we mean by relevance? Well, only evidence that's relevant may be admitted during trial. So, if it is irrelevant, if it is not related to the case, it cannot come in. So we only allow relevant testimony. And even some testimony that may otherwise be relevant, going back to my photograph example, we keep it out because it is unfairly prejudicial to the other side. So if a question were to come up during your mock trial that is, let's say we want to ask questions about a witness's, I'm really trying hard not to coach you here. Here's what I would say to this. If you work this out with your teammates, because, well, let me think of it from another case. I'm trying not to use this case in particular, okay? Let's say it's a DUI case, and the question was for the police officer about where he goes to church. Now, unless that's related to the DUI, it's not relevant about the police officer and where he went to church. Just made that one up on the spot. Not the best example, but I'm really trying to avoid the actual mock trial packet. It's getting harder and harder as we get further into these videos. I'm sorry. But relevance. We don't allow testimony to come in that's not relevant. Next, leading questions. An objection to a leading question. Now, if you've been watching these videos, you will know by now that on cross-examination we ask leading questions, right? And on direct, we ask direct questions, open-ended questions. And on cross-examination, we ask leading, narrow, that only call for a yes or no question, typically, yes or no response. So a leading question on direct would call for an objection by the other side that question is leading. So if I'm the prosecution, I call a police officer and I ask something like, isn't it true, police officer, you've done 500 murder investigations? That is a leading question. It should be an objection by the defense. Improper character testimony. Only when the witness's character is called into question do we allow character testimony. And so improper character testimony would be to testimony brought in to boost the credibility of a witness. Now, in your mock trial, you're limited by the witnesses you have, so really this doesn't happen very often, but if it were, make sure you know what an improper character testimony is. If a witness is trying to build up the character of another witness. Opinion. We have two types of witnesses in the mock trial, right? We have our lay witness and our expert witness. Our lay witness, they can only testify to the things they observed. So they cannot, in most cases, render an opinion to the things that are material to the case. However, if you have expert witnesses, if you have a doctor, if you have a psychologist, they may render an opinion if they are qualified as an expert to do so. And we'll talk about that in the witnesses' testimony. I think I might put it in the evidence video here. Lack of personal knowledge. If a person does not have knowledge about what occurred and you're going to ask them a question about it, so let's say that you are a witness who comes to the scene of something that occurred, if you ask them questions about something that happened earlier in the day, they may not have personal knowledge about that. So if that would be a proper objection if you say, what occurred earlier in the day. So lack of personal knowledge, you would object to that. A question calling for a narrative. If it's okay, and I would recommend, this is not coaching, this comes from your mock trial packet, I would recommend that you ask open-ended questions like, tell me about your training and experience to a witness. That could call for a narrative. However, it's okay because we allow that in the beginning of testimony. However, if you have a witness, I would not say, tell me everything you know about this case. That calls for a narrative. But asking somebody what happened on a certain date or what did you do, that doesn't call for a narrative. It does to some extent, but it's not asking them to tell me everything about the case. That would be calling for a narrative. A non-responsive answer. Now, remember I said you can object to the question and to the preventing testimony. So, if a witness is asked a question and they give an answer that's non-responsive, you object to that answer for being non-responsive, ask for that answer to be stricken, and ask the question again. Or sometimes you don't object and you just keep asking the question. But a non-responsive answer by a witness is objectionable. Hearsay, and we'll get into the exceptions of hearsay, but what is hearsay? This is tough for CC students. Hearsay is an out-of-court statement offered in court to prove the truthfulness of that statement. So hearsay would be if I came into court and I said, I heard Mrs. Klepper say something, and I'm offering what I heard her say to prove the truthfulness of that statement. So if I came into court and I said, I heard Mrs. Klepper say that it was raining outside. If I come into court to prove that it was raining outside by using Mrs. Klepper's statement that I heard her say it was raining outside, therefore that must be truthful, that's hearsay. I could bring Mrs. Klepper in to say, what did you say? And she could say, I came in and said it was raining outside. But I can't use that statement by Mrs. Klepper to prove that it was raining outside. This is complicated. And it's even more complicated because we have exceptions to the hearsay rule, which we'll get into one second. The other objection is improper extrapolation of fact. If you were to take the mock trial packet, extrapolate something from it, create new facts, that would be improper extrapolation of facts. So these are our main objections. Now hearsay. Let's talk about the exceptions to the hearsay rule. We're going to go over my 10-minute video. I apologize, but this is important stuff. So in hearsay, we have exceptions to the hearsay rule. And these are our hearsay rule and exceptions. Number one, the biggest one is, I am not offering this testimony for the truthfulness therein. So, for example, if I was offering a testimony about Mrs. Klepper, that she told me that it was raining outside, I'm not offering it to prove that it was raining outside. I'm offering it for another reason. And the other reason is, I offered it to prove that I heard Mrs. Klepper say something. Not what I heard her say, but I offered to prove that I heard her say something for some other reason. So I'm not offering it for the truthfulness of the statement. I'm offering it for another reason. We have another exception, present sense impression. So a statement offered by a witness near the time that they sensed something, that they saw something, is not hearsay. So if somebody witnessed a car accident and at the time that they saw it, or let's not use car accident because I want to get into the next one. Mrs. Klepper came in and said it's raining outside. That may be an exception to the hearsay rule because it was a present sense impression. She's offering it at the time that she experienced something, and therefore then that's not hearsay. Excited utterance. Excited utterances are things offered when somebody's under a stressful situation. So if somebody says, I just saw someone shoot somebody, that would be an excited utterance. How about a statement offered to describe a mental, physical, or emotional condition? If you go to the doctor and you say, I'm sick, and the witness and a nurse hears that, your statement that I'm sick is not here. It is hearsay, but it's an exception to the hearsay rule because it's been offered for a mental, physical, or describing a mental, physical, or emotional condition. The physical condition being I'm sick. A recorded recollection. If you've written something down, or a witness has written something down, and now we're offering it in court for impeachment or to describe someone, then that would be a recorded recollection. That's not hearsay. Records of regularly conducted business activity. If in the course of a business, a company keeps regular records, that is not hearsay. So that is offered because it has an it is hearsay, but it's an exception to the hearsay rule in that it is a regularly conducted business record. Evidence to someone's reputation or character. That's not hearsay if it's offered to prove the truthfulness of someone's reputation or character. Judgment of prior conviction. A judgment of prior conviction is an exception to the hearsay rule, and it is offered in testimony to prove someone has been convicted of a crime if, and only if, that evidence is being offered and it meets that crime that someone has been convicted of, meets the exceptions as provided in your mock trial packet. And those two specific examples, a crime of a certain type of crime, a grading, or another type would be if it involves dishonesty. So that would be a judgment of a prior conviction. If the declarant, if the person who said it is unavailable, it is an exception to the hearsay rule. Because witnesses who are unavailable, we need to get their testimony in. So for an example would be somebody who's been killed. If they are dead, they're unavailable. So we can't offer their testimony. We can't have them come in and testify. However, we can offer their testimony through someone else who heard them say something because they are unavailable. They're unavailable, and then their testimony is an exception to the hearsay rule. Another exception, often overlooked, defendant's own words. This is what the whole Miranda thing is about in the mock trial packet. Your words can be used against you. A defendant's words can be offered against them in a mock trial or any trial, and that is not hearsay. So the words spoken by a defendant are not hearsay. They're an exception to the hearsay rule. All right. If you have specific questions about objections and about this part, which is very complicated, send me a message on Facebook. I post these videos via Facebook and we put them on YouTube. Send me a private message, and I would be happy during this coronavirus time while we're all locked in our home to do a Zoom talk with your class or with your student, with a parent, to walk through these and discuss these in more detail. I just won't tell you when to object, but I can talk generally about objections because this is complicated, and a lot of even attorneys take a long time to get this. So really focus on these that come from the packet, and then over here I want you to focus on the hearsay rule exceptions. And for my class in Carlisle, we're going to be going over this on Tuesday anyway, because we're going to have some things to cover during our regular scheduled time, although we won't be meeting in person because we're complying with the quarantine. Hope this is helpful. I'm going to get this uploaded and work on the next video. Have a great day. Stay healthy. Wash your hands. And we'll get through this. Bye-bye.